Indian Penal Code that deals with offenses against sex, or particularly offenses against women, are broadly dealing with two particular offenses previous to the Criminal Law Amendment 2013. Section 354 and Section 375, 376 and 377. So far, 375, 376 and 377 are concerned, that offenses are called against the sex. So far, Section 354 is concerned, previously that merely deals with force or assault with intent to outrage the modesty of woman. Now, so far offense of rape is concerned, the original definition of rape is somewhere constrained, and it is having the concept of consent in different manner, in restricted manner. Rather than different, I want to use the restricted manner. But considering the development in society, considering the changes in lifestyle, considering the westernization, and number of incidents which are not covered under the previous provision of Indian Penal Code section 375, as well as one of the brutal murder along with the rape which has takes place, which we all recognize as a Nirbhaya's case, has drastically influenced on the provision which are dealing with the rape, and that sought to be changed by the Criminal Law Amendment Act 2013. And therefore, the drastic change takes place in Criminal Law Amendment Act 2013, and it has drastically changed the gamut of the term rape as well as the offenses dealing with the sexual harassment. Previously or before 2013, we cannot find the concept of sexual harassment. There is no definition yet regarding the concept of sexual harassment in Indian Penal Code. Only it can be seen in section 354A. This is the impact of Criminal Law Amendment Act 2013. Therefore, we can say that Criminal Law Amendment Act 2013 particularly deals with the enhancement of provisions or punishment in offenses against the woman or offenses against the sexual harassment and rape. So far, the amendment which has drastically changed the view. Even previously, some drastic changes takes place or some judicial pronouncement compel the legislator to change the gamut of concept of rape. 2013च्या क्रिमिनल लॉ अमेंडमेंट ऍक्टने इंडियन पिनल कोड भारतीय दंडविधान कायद्याच्या 354 आणि 375 ते 77 ह्या प्रोव्हिजन मध्ये खूप मोठ्या प्रमाणात बदल घडवून आणला. आणि हा बदल घडण्याचं मुख्य कारण म्हणजे समाजात बदललेलं लाईव्हलीहूड, पद्धत जगण्याची झालेली डेव्हलपमेंट, वेस्टर्नायझेशन, चेंज इन कल्चर, या सगळ्या गोष्टीचा इम्पॅक्ट आपल्याला या अमेंडमेंट मध्ये बघायला मिळतो. The main reason definitely we can say that the Nirbhaya's incident 16 डिसेंबर 2012, on 16 December 2012, a brutal murder and gang rape takes place in running bus in New Delhi, and that reflect the people's mind or aggression towards the legislator, towards the criminal law, and that compel the central government to appoint a committee for revising or some changes in the criminal law, particularly dealings with the offenses against the rape. 2012च्या निर्भया प्रकरणामुळे क्रिमिनल लॉ मध्ये रेप या प्रोव्हिजनला घेऊन असलेली शिक्षा याच्यामध्ये वाढ होण्यासाठी, किंवा सामान्यपणे आपण असं म्हणू की जे पीपल ॲग्रेशन होतं की बलात्कार या गुन्ह्यासाठी फाशीचीच शिक्षा असायला पाहिजेत, याच्यासाठी बरेचसे मोर्चे आणि उठाव आपण बघितले. त्याचा इम्पॅक्ट म्हणून सेंट्रल गव्हर्नमेंटने जस्टिस वर्माच्या चेअरमनशिप खाली एक कमिटी एस्टॅब्लिश केली, and the committee of Justice Verma has recommended for some reversion as well as insertion of new provision in these topics. Justice Verma's committee has sought some changes in criminal law along with Criminal Major Act, means Criminal Procedure Code and Evidence Act. 2013च्या क्रिमिनल लॉ अमेंडमेंट ऍक्टने फक्त इंडियन पिनल कोड किंवा फक्त 375, 76, 77 ह्यामध्येच बदल केला नाही, तर 2013च्या क्रिमिनल लॉ अमेंडमेंट ऍक्टने प्रोसिजरल लॉ, ऍडजेक्टिव्ह लॉ, सबस्टेंटिव्ह लॉ या तिन्हीमध्ये सुद्धा ड्रास्टिकली काही नवीन प्रोव्हिजन आणि काही जुन्या प्रोव्हिजन मध्ये नवीन गोष्टी ऍड केल्या, आणि म्हणून आपल्याला 2013चा क्रिमिनल लॉ अमेंडमेंट ऍक्ट जो आहे तो रेप ह्या कन्सेप्टची गॅमेट चेंज करताना दिसतो. दॅट इज द बेसिक रिझन. नाउ सो फार क्रिमिनल लॉ अमेंडमेंट ऍक्ट 2013 याचे ब्रॉड रिफ्लेक्शन जर आपण 2-3 वाक्यात मांडायचं ठरवलं, की 3 वाक्यात आपल्याला विचारलं की व्हॉट आर द चेंजेस टेक्स प्लेस बाय द क्रिमिनल लॉ अमेंडमेंट ऍक्ट 2013, तर ह्याच्यात बेसिकली पहिल्यांदा आपल्याला असं सांगता येईल की 354A मध्ये सेक्स्युअल हॅरॅसमेंटची कन्सेप्ट डिफाईन करून त्याच्याबद्दलची शिक्षा नॅरेट करण्यात आली. पूर्वी जे 354 होतं दॅट डील्स विथ असॉल्ट और क्रिमिनल फोर्स विथ altering the modesty of the woman. If you overlook previous provision, you cannot find the concept of sexual harassment. Even there is no definition of sexual harassment in the preliminary or the chapter of Indian Penal Code. So this new concept has been defined and deals by the Criminal Law Amendment Act 2013. Now after that, the drastic change which has made by the Criminal Law Amendment Act in the definition of rape. रेपच्या 375च्या डेफिनेशन मध्ये ह्या क्रिमिनल लॉ अमेंडमेंट ऍक्टनी जवळपास 6 प्रकारच्या नवीन गोष्टी ऍड केल्या. आय एम सेइंग 6 काइंड्स ऑफ न्यू थिंग्स विच प्रिव्हियसली नॉट प्रेझेंट, राईट नाउ दॅट्स आर प्रेझेंट in section 375 of Indian Penal Code, which deals with definition of rape. Now see what I am saying, that the concept of rape previous to the landmark judgment and subsequently to that landmark judgment and now are having drastic changes. Now what referring the landmark judgment which has been strongly criticized. निर्भयाच प्रकरण असं काही नाही की ह्या सेक्शन बद्दल जनसामान्यामध्ये उठाव झाला. यापूर्वीच्या अशा भरपूर काही गोष्टी आहेत, किंवा सगळ्यांना माहित असेल LLB शिकत असताना आपण तुकाराम अँड अदर्स वर्सेस स्टेट ऑफ महाराष्ट्र ही केस ऑलमोस्ट सगळ्यांनाच माहिती आहे. दॅट हॅज ऑल्सो क्रिटिसाइज ऑन द ज्युडिशियल व्ह्यू अँड द डिसिजन गिवन बाय सुप्रीम कोर्ट इन तुकाराम अँड अदर्स वर्सेस स्टेट ऑफ महाराष्ट्र. The basic problem in Tukaram versus State of Maharashtra, which has been criticized by a lot of legends of law also, that the definition of rape, the concept of consent in 375 is constrained prior to this amendment. Now it has drastically changed. So main focus rather than the inclusion, you are required to understand the changing concept of definition of rape. That is the major change bring by the Criminal Law Amendment Act. Along with that, third thing. Now, two things I have already emphasized. Firstly, that sexual harassment has been defined. Secondly, that the definition of rape has undergone change. And thirdly, that minimum punishment has been precised by the Criminal Law Amendment Act. Previously, in certain circumstances, the judiciary get discretion to give minimum punishment because minimum punishment is not narrated in the previous section's punishment under section 376. Right now, after the amendment of 2013, the minimum punishment has been prescribed. So whoever held guilty or whoever or against whom the said allegation has been proved, now there is no discretion to the court to give less punishment than that. So minimum punishment, that is also a new thing which has been bring by the Criminal Law Amendment Act 2013. So these are the broad thing which you have to understand. Apart from that, lot of things you can narrate, but basically this thing has drastically changed the gamut of the offenses against the rape or sexual harassment. Now, so far, merely the Criminal Law Amendment Act 2013 is concerned. Up to it, I focus on section 375 or 354. Now, if we generally overlook, so far the amendment is concerned, the Criminal Law Amendment Act 2013 not merely insert or changes the provision under section 354 or 377, but it has changed drastically some other provision and some information technology technical things as well as adjective provision and procedural provision are also has been changed by this Criminal Law Amendment Act. Now, merely for reflection that what broad changes bring by the Criminal Law Amendment Act 2013, we will overlook what provisions has been added in the Criminal Major Act. Now, I am not talking about merely Indian Penal Code. I am saying Criminal Major Act. Criminal Major Act means the Indian Penal Code, Criminal Procedure Code, and the Evidence Act. If we see the Indian Penal Code after 2013, one thing which is added under section 100, that seventh kind of situation wherein a right of private defense can be extended up to the death of the aggressor. Acidic attack. Section 100 of Indian Penal Code. That is brings by this Criminal Law Amendment Act. Then next, section 166A. Indian Penal Code, section 166A, 166B. Now, this provision has compelled the public servant or police department for registering the offense and sought the investigation. That has compelled. These are the changes bring by the Criminal Law Amendment Act 2030. Section 166 was section 166A and 166B. Apart from that, section 326A and 326B, that are the newly added provision in Indian Penal Code by the Criminal Law Amendment Act 2013. Now, after that, section 376, section 376AB, DA, BD, these are the new three provision as added. Apart from that, I am talking only the new added provision. I am not talking what चेंजेस टेक्स प्लेस इन अ प्रिव्हियस प्रोव्हिजन. आधीच्या प्रोव्हिजन मध्ये काय चेंजेस झाले ते नाही सांगत आहे, कुठले नवीन प्रोव्हिजन आले ते सांगतोय. दॅट सेक्शन 376 AB, DA, 376 DA, 376 BD, these are the provisions added by the criminal law amendment. So far section 354 is concerned, section 354 A, B, C, D, these are new provisions added in criminal law by the Criminal Law Amendment Act 2013. These are the mere examples. Apart from that, you can find some provision which has been added. Now after that, the Evidence Act. What is the impact of this Criminal Law Amendment Act 2013 on Evidence Act? 2013च्या क्रिमिनल लॉ अमेंडमेंट ऍक्टने सेक्शन कुठले कुठले एव्हिडन्स मध्ये इन्क्लूड झाले किंवा काय बदल झाले. बेसिकली यू कॅन फाइंड सेक्शन 53A. 53A is inserted in Indian Evidence Act. That is the amendment sought by Criminal Law Amendment Act 2013. Apart from that, section 146, some changes has been takes place in section 146 so far, the Criminal Law Amendment Act 2013. Now after that, this is the adjective law. Rather than that, more impact takes place in procedural law by this Amendment Act. This Amendment Act added or changed some provision of Criminal Procedure Code, and firstly you can find the impact of Criminal Law Amendment Act on section 154 of CRPC. Section 154 subclause 1 has added two new sub and subclauses that provide the procedure for registering the FIR in case of offenses against the woman, or particularly the rape and sexual harassment. Even apart from that, some changes has been takes place under section 166 as well as 164, 173 of Criminal Procedure Code. Apart from that, you can find some changes or amendment under section 309, 327, 357B, 374, 377, 438 of Criminal Procedure Code. So this is the impact of Criminal Law Amendment Act 2013 on substantive law, on adjective law, as well as the procedural law, that is CRPC. Therefore, this amendment has drastically changed the offenses and the punishment so far sexual harassment and rape is concerned. Hopes that you have understand what are the basic changes takes place so far the Criminal Law Amendment Act 2013. I know that this session is particularly going on for the student who are preparing for the interview of APP. So rather than focusing merely on the provisions or content of this act, you must know that from where this amendment comes and what are the parameter of this amendment and why legislator has make these amendments. If you see the basic reason behind it, that is the aggression takes place in Nirbhaya's case, and due to that the central government has appointed the committee headed by Justice J.S. Verma, and the report was submitted by J.S. Verma on 23rd January 2013. And this committee focus on the gender justice and making existing law computable for gender justice. The main focus of the Verma committee is to bring the gender justice and making the appropriate provision for curbing the offenses dealing with the gender justice. Now, if we see the Justice Verma's report, naturally that report is too much bulky, and there are n number of recommendations made by the committee, but naturally that has not blindly followed by the central government, and that can reflect in the Criminal Law Amendment Act. जस्टिस वर्माच्या कमिटीने जे दिलेले सर्व रिकमेंडेशन आहेत ते खूप जास्त आहेत. ते ॲज इट इज काही फॉलो झाले नाही. सम recommendations of the committee has been used and the amendment takes place pertaining to this act. 2013च्या क्रिमिनल लॉ अमेंडमेंट ऍक्ट मध्ये जस्टिस वर्मा कमिटीने दिलेले खूप सारे रिकमेंडेशन फॉलो केलेले नाहीत. आय एम सेइंग दॅट not blindly followed or not fully followed. So far Justice Verma's committee is concerned, if someone or panel asks you what are the recommendation apart from the criminal law amendment by the Justice Verma's committee, जस्टिस वर्मांच्या कमिटीने दिलेले सर्व रिकमेंडेशन फॉलो केले गेले का, असा जर प्रश्न विचारला तर तुम्हाला डेफिनेटली त्याचं उत्तर सांगता आलं पाहिजे. इट्स माय पर्सनल एक्सपिरियन्स सो फार दी इंटरव्ह्यू ऑफ JMFC इज कन्सर्न. ज्यावेळी JMFCच्या इंटरव्ह्यूला मी अपियर झालो त्यावेळेस मल्लीमठ कमिटीज रिपोर्ट वॉज बर्निंग रिपोर्ट सो फार दी ड्रास्टिक चेंजेस इन द क्रिमिनल जस्टिस सिस्टम इन इंडिया. म्हणून त्यावेळेस मल्लीमठ कमिटीचे रिपोर्ट्स किती फॉलो झाले आणि किती नाही याच्यावर पॅनलने बऱ्याच लोकांना प्रश्न विचारले होते. आता क्रिमिनल लॉ अमेंडमेंट ऍक्ट 2013 अँड 2018 याचा मेन सोर्स आहे दॅट कॅन बी सीन दॅट द रिकमेंडेशन मेड बाय द जस्टिस वर्माज कमिटी. So you must know that what kind of recommendation which has not followed by the legislator while amending the criminal law. 2013 किंवा 2018च्या क्रिमिनल लॉ अमेंडमेंट मध्ये जस्टिस वर्माचे कुठले कुठले रिकमेंडेशन्स होते जे फॉलो केलेले दिसत नाहीत, कॅरी ऑन केलेले दिसत नाहीत, हे जर विचारलं तर ते तुम्हाला बघायला पाहिजेत आणि त्याचं उत्तर माहित असायला पाहिजे. Justice Verma's committee did not report or mention any kind of the basic thing. I am not saying regarding what report has not been followed. What is the focus of Justice Verma? Justice Verma ने काय फोकस केलं होतं ते ॲज इट इज फॉलो झालं आणि काय फॉलो झालं नाही ते आपण सायमल्टेनियसली डिस्कस करू. Justice Verma's committee report did not mention death penalty as a punishment for rapists and insisted or inserted suggestion as an imprisonment for 20 years. But the final ordinance passed terminated the punishment of rapists to be a minimum 20 years imprisonment for the rapist and even death penalty in extreme cases. Justice Verma not recommended anywhere the death penalty for the offense of rape and murder. But that has been made the changes in the Criminal Law Amendment Act. So far Criminal Law Amendment Act 2013 is concerned, Criminal Law Amendment Act rejected Justice Verma's committee's suggestion of criminalizing marital rape. Justice Verma's committee has recommended the punishment for marital rape, but yet there is no provision in Indian Penal Code or even in Criminal Law Amendment Act 2013 pertaining to marital rape. There is no change. Previously that is going to be recognized and the age criteria is there rather than the marital rape. Marital rape अशी concept अजून सुद्धा as it is recognized केली गेलेली नाहीये. That is going to be retreated in another way. The act rejected the proposal of Justice Verma that no politician should be allowed to contest the election. Now this is the, you can say that, laughing suggestion which has not followed, particularly the politicians. Justice Verma's committee recommended that once the allegation or any trial is going on pertaining to offense of rape or sexual harassment against the politician, they should not allow the contesting of election. that is not followed in the Criminal Law Amendment Act, either in the procedure or either in the substantive. Now, these are the broad three things which has been not followed by the legislator while amending the Criminal Law Amendment Act 2013. बेसिकली ह्या तीन गोष्टी फोकस करता येतील आपल्याला, की जिथे जस्टिस वर्माच्या कमिटीने जे रिकमेंडेशन केले होते ते रिकमेंडेशन लेजिस्लेटरने क्रिमिनल लॉ अमेंडमेंट ऍक्टचे प्रोव्हिजन नवीन किंवा इन्सर्ट करत असताना फॉलो केलेले दिसत नाहीत. So this is the Justice Verma's committee reports and its impact on the criminal law, particularly section 354 and section 375. Now, so far this amendment is concerned, for the term sexual harassment, yet Indian Penal Code has not provided any particular section in the preliminary. It has referred the definition which is provided in the sexual harassment of women at working place, particularly that act is enacted. Sexual harassment of women at working place, that act section 2 has defined the term of sexual harassment, and that is going to be followed as it is in Indian Penal Code so far section 354A is concerned. 354A मध्ये जी सेक्शुअल हॅरॅसमेंटची डेफिनेशन आहे ती डेफिनेशन इंडियन पिनल कोड मध्ये कुठेही इन्सर्ट नाहीये. तिचा रेफरन्स सेक्शुअल हॅरॅसमेंट ऑफ वुमन ॲट वर्किंग प्लेस ह्या ऍक्ट मधल्या सेक्शन 2 मधला इकडे रेफर केलेला आहे. If the panel asks you where the term sexual harassment has been defined, then you can merely refer section 354A, because there is no particular definition of sexual harassment rather than section 354A. 354A सोडलं तर दुसऱ्या कुठल्याही प्रोव्हिजन मध्ये किंवा प्रिलिमिनरीच्या डेफिनेशन्स किंवा एक्सप्लेनेशन मध्ये तुम्हाला सेक्शुअल हॅरॅसमेंटची डेफिनेशन बघायला मिळणार नाही. Now this is pertaining to the Criminal Law Amendment Act 2013. We can discuss the changes and focus of criminal law justice. Lot of time, lot of things has takes place. But due to the time constraint, we will start our substantive law and then we will discuss what are the actual impact on the substantive law regarding this Criminal Law Amendment Act. 2013च्या क्रिमिनल लॉ अमेंडमेंट ऍक्ट मध्ये इंडियन पिनल कोड मध्ये sexual harassment and punishment for sexual harassment, this new provision is added in section 354A. Section 354A that deals with the three clauses. There are three clauses in this section. Now, so far clause first is concerned, it says a man committing any of the following acts. Now see, I always say that, or even my previous session, if you try to understand, I always say that you have to focus on the opening word. Section 354A particularly emphasizes a man committing any of the following act. Means so far section 354A is concerned, accused is always a man. Woman cannot be subject matter of this provision as an accused. A man committing any of the following acts, that are four kinds of act narrated in section 354A, subclause 1, physical contact, demand or request of sexual favor, showing pornography, or making sexual colored remark. These are the four things narrated under section 354A, subclause 1, 1, 2, 3, 4. Making sexual colorable remarks shall be guilty of offenses of sexual harassment. Here, firstly, the word can be seen sexual harassment. If you observe section 354, तुम्ही 354 प्रिव्हियस टू अमेंडमेंट जर बघितला तर त्याच्यात सेक्शुअल हॅरॅसमेंट असा शब्द बघायला मिळणार नाही. Here this term sexual harassment is firstly used by Indian Penal Code. Clause second of this section says, any man who commits the offense specified in clause first or clause second or clause third of subsection first shall be punished with rigorous imprisonment for a term which may extend to 3 years or with fine or both. Means section 354A subclause 2 merely provide the punishment for the act which has been contained in subclause first number 1, 2, 3, and for the punishment of section 354 subclause A, fourth thing, any man who commits the offense specified in clause 4th of subsection 1st shall be punished with imprisonment of either description for a term which may extend to 1 year or with fine or both. Means section 354A, which has provided two kinds of punishment for sexual harassment made by any of the act which is contained in section 354 subclause A subclause 1 part 1 to 3, that is 3 years punishment, and for the fourth clause it is 1 year's imprisonment. This provision plainly deals with the sexual harassment. The title of this provision is sexual harassment and punishment for sexual harassment. Now so far this offense is concerned, you can see the procedural law that cognizable, bailable, non-bailable, triable by magistrate. Now so far section 354B is concerned. This is the second provision which has been inserted or added by Criminal Law Amendment Act 2013. 2013च्या क्रिमिनल लॉ अमेंडमेंट ऍक्टने 354B हे नवीन प्रोव्हिजन इंडियन पिनल कोड मध्ये ऍड केलं, that deals with assault or use of criminal force to women with intent to disrupt. Now previous 4-5 words are similar which are contained in section 354 of Indian Penal Code. 354 मध्ये assault or criminal force to woman with intent to outrage her modesty असा रेफरन्स आहे तिकडे. इथे assault or use of criminal force to woman with intent to disrupt. Now why I am focusing on the bold wording of this provision, that each and every provision is narrating the different offense. 354 चे 5 प्रोव्हिजन आहेत आता इंडियन पिनल कोड मध्ये. 354, 354A, 354B, 354C आणि 354D. All are dealing with the outering modesty of the woman. Only the modus operandi has been changed and the different provision is applicable and punishment is as per the different provision. So whenever assault or force or criminal force to woman with intent to disrupt. Now disrupt is the term wherein you can say or you can understand disrupt means or nothing but or compelling her to be naked. Whenever by using the assault or criminal force, when a man, focus that every provision has started any man who assault, means here the accused always must be a man. Woman cannot be held responsible for this provision. So far compel her to be naked shall be punished with imprisonment of either description for a term which shall not less than 3 years but which may extend to 7 years and shall also be liable to fine. So section 354A, section 354B, that particularly deals with sexual harassment, but the modus operandi or performing the act or sexual harassment is in different manner. Here for section 354, the criminal force or assault has been particularly used to compel a woman to be naked. That is the intent. If section 354B is required to be attracted, the intention of the culprit or accused is nothing but to disrupt the woman. That must be the intention. If this intention is attracted, then and then only section 354B is applicable, or offense can be registered under this section. Now, so far this section is concerned, it has provided the enhanced punishment for the second or third attempt that may be extended up to 3 years to 7 years also, and also deals with the fine also. Not only the punishment, but fine is also there. Now, these are the two provisions. The remaining two provisions are having the different things. Now, if you focus on the wording of the further provision, section 354C and 354D is concerned, you can more reflect the modus operandus of committing such kind of offense, wherein the use of information technology or IT has been used, or such kind of crimes are going to be committed by using the information technology or techniques. So this is the change between these two provision and remaining two provision. So far section 354C is concerned, any man who watches or capture the image of woman engage in a private act in circumstances where she would usually have expected not being observed by either by the perpetrator or by any other person at the behest of the perpetrator. Now see, rather than actual wording, I will give a meaning of this section. Here, if any woman performing any private work at any place with her consent, whether it is bad or good, capturing it without her intent or consent is made it offense. This offense is going to be registered against the person who is capturing that image. So far the perpetrator is concerned, either he has to take the consent, otherwise he is not allowed to capture the image whenever the woman is engaged in any private act and she considered or she feel that no one rather than the person, though she is performing any private act along with someone, his partner or whatever it may be, if the perpetrator is not having consent to capture that, that is the offense. Now you can find that this provision can be attracted in lot of activities which you can see the Facebook and all the social medias. Therefore, I have reflected that this provision particularly deals with the modus operandus wherein the use of information technology is the way of performing this act. 2013च्या क्रिमिनल लॉ अमेंडमेंट नंतर 354C आणि 354D हे दोन प्रोव्हिजन जे ऍड झाले, त्याच्यामध्ये मोस्टली मोडस ऑपरेंटस जो आहे तो इन्फॉर्मेशन टेक्नॉलॉजीचा वापर करून केलेल्या कृत्याचं रिफ्लेक्शन आपल्याला 354C आणि डी मध्ये बघायला मिळतं. नाउ सो फार the voyeurism is concerned, section 354 subclause C is concerned, the punishment for the first conviction with the imprisonment of either description for a term which shall not less than 1 year but which may extend to 3 years. Now here try to remember that what basic thing which has bring by the Criminal Law Amendment Act 2013. पूर्वी इंडियन पिनल कोड मध्ये मिनिमम पनिशमेंट देण्याची पद्धत बघायला मिळत नव्हती. नाउ हियर यू कॅन डायरेक्टली फोकस दॅट फॉर द फर्स्ट कन्व्हिक्शन द पनिशमेंट शॅल बी नॉट लेस दॅन 1 years. Means less punishment is minimized here by the Indian Penal Code and it can be extended up to the 3 years. पूर्वी कमीत कमी किती शिक्षा द्यावी हे इंडियन पिनल कोडच्या कुठल्याही प्रोव्हिजन मध्ये बघायला मिळत नव्हतं. आता 2000च्या क्रिमिनल लॉ अमेंडमेंट ऍक्टने कमीत कमी किती द्यायची, जास्तीत जास्त किती देता येईल ह्या दोन गोष्टी असू शकतात किंवा आहेत. त्याचं बेस्ट एक्झाम्पल सेक्शन 354 सबक्लॉज 354C. याच्यात मिनिमम पनिशमेंट 1 इयर्स आहे, मॅक्झिमम पनिशमेंट 3 इयर्स. अलॉंग विथ धिस दॅट एक्सप्लेनेशन, मी जी गोष्ट सांगितली त्याचं एक्सप्लेनेशन तुम्हाला सेक्शन 354 सबक्लॉज सी मध्ये बघायला मिळेल. फॉर द पर्पज ऑफ धिस सेक्शन, private act include an act of watching carried out in a place which in the circumstances would reasonably be expected to provide privacy, and where the victims gently purports or breaks are exposed or convert only in all these things that underwear victim is using. These are the wording has been used wherein generally the private acts are going to be performed, and naturally the women are not expected that someone should capture these images. So this offense is particularly taking or capturing the images of the woman while she is performing his private act, or you can say that such kind of act generally which is not going to be performed by the woman at or in front of the layman or other mans. This is section 356 354C. Now so far section 354D is concerned. Now this is purely, you can say that cyber crime. I'm using particular word that section 354 deals with the cyber crime, that is called as stalking. This is the term used in the information technology only. There are a lot of confusion regarding the cyber law in India. Whenever we say that cyber law in India, we naturally focus on the Information Technology Act. If someone asks you which is the cyber law in India, you are not allowed merely to focus on Information Technology Act. Even the Indian Penal Code also deals with some kind of offenses dealing with this cyber crime, and this is the important provision which is available in Indian Penal Code that deals with the stalking, section 354D. इंडियन पिनल कोडच्या 354D मध्ये जो स्टॉकिंगचा ऑफेन्स आहे त्याला सायबर क्राईम म्हणावं लागेल. So far section 354D is concerned, if we see the actual wording, 354D ची actual wording जर तुम्ही बघितली तर तुमच्या सहज लक्षात येईल how we can call it as an cyber crime. Section 354D subclause first contended, any man who, again any man is there is no change in gamut of offenses against sexual harassment or rape. Any man who follows a woman and contact or attempt to contact such woman or foster personally interaction repeatedly despite a clear indication of disinterested by such woman, or now or this is the second clause is more important, which reflect this provision in the cyber crime. Monitor the use by women of the internet, email, or any other form of electronic communication commits the offense of stalking. Now recall my wording that I am saying section 354D is the cyber crime. Section 354D subclause 2 particularly contended, means subclause 1 second clause deals with monitoring the use by a woman of internet. Whenever a man monitors the using of women, so far internet or email or any other platform as like WhatsApp, Twitter, Facebook, whatever it may, any communication, electronic communication device which is going to be used by the woman, if someone monitoring that, it amounts to the offense of stalking. Provide that such contact shall amount to stalking if the man who proposed it provides that it was pursued for the purpose of preventing. Now this is nothing but the defenses can take place. It was proposed for the purpose of preventing or dictating crime, and man accused of the stalking had been entrusted with the responsibility of preventing and detecting of the crime by the state, or it pursued under any law or to compel with any condition. Means section 354D subclause 1, which provide two or three circumstances which has been justified if monitoring takes place regarding the use of any electronic communication. If it is either with the intent to prevent the crime, it is either with intent to dealing with the enforcement of any law, or it pursued under the law for or to compelling the condition or requirement imposed by the law any person under any particular situation. That's are the, you can say, justification for that anyone can monitor the use of internet or electronic communication. This is section 354D subclause 1. Subclause 2 of section 354D deals with whoever commits the offense of stalking shall be punished on first conviction with the imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine, and the punishment on second or subsequent conviction the imprisonment of either description which may extend to 5 years and shall also be liable to fine. Means for the first conviction, the punishment is deals with the 3 years, and for second or subsequent conviction, it may be extended up to the 5 years along with the fine. Section 354D that particularly deals with the offense of stalking, and this stalking deals with nothing but the monitoring of use of electronic communication by any woman. That is the offense of stalking. You cannot find the similar provision in even Information Technology Act. Here Indian Penal Code has made it very clear that monitoring is nothing but like the previous offense as section 354D has been particularly contended. Even the woman particularly inform the person who is monitoring that she is disinterested. That is also comes in the stalking. This provision is particularly enacted to prevent the harassment of women on the social media platform. I am making very bold statement, though it is not contended in the act. This provision is particularly deals with prevention of such kind of activities which has generally takes place on social media as like WhatsApp, Twitter, Telegram, Facebook and all these things. You may more know about me. माझ्यापेक्षा तुम्हाला जास्त सोशल साइट्स माहित असतील. So all these social sites can be the playground for these offenses, and that has been particularly made punishable in Indian Penal Code so far. The offenses narrated in section 354 A, B, C, D. These all four provisions has been added by the Criminal Law Amendment Act. हे चारही प्रोव्हिजन क्रिमिनल लॉ अमेंडमेंट ऍक्टने इंडियन पिनल कोड मध्ये इन्सर्ट झाले. 354 जो प्रिव्हियस होता दॅट वॉज प्लेन दॅट नियरली डील्स विथ assault or criminal force with intent to altering the modesty of the woman. Now it has included the sexual harassment as well as some cyber offenses dealing in section 354 C and D. So this is the great impact of Criminal Law Amendment Act 2013 dealing with the offenses against the sexual harassment. Now after that, naturally the impact of Criminal Law Amendment Act 2013 takes place in offenses against rape and all these things. Now dear friends, if we see the previous definition of rape, as I have already contended that the concept of concept is too much narrower. To understand the changes in Criminal Law Amendment Act 2013, you must know previous situation. 2013 पूर्वी किंबहुना त्याच्यापूर्वी कन्सेंटची कन्सेप्ट काय होती हे जोपर्यंत तुम्हाला माहित नसणार आहे तोपर्यंत क्रिमिनल लॉने या अमेंडमेंटने नेमका काय बदल केला तो तुमच्या लक्षात येणार. There are lot of confusion regarding the concept of consent, and always the cases are going to be contest on the basis of against her will without her consent. Most of the cases are dealing on this point. Contesting point काय असतो? Against her will or without her consent. That always create an contesting point. So far there are some landmark judgment dealing with the concept of consent. Even in Mathura's case, the consent has been differently read by the apex court, and that was criticized mostly by a legend or the people who are dealing with the laws. तुकाराम अँड अदर्स वर्सेस मथुराच्या जजमेंटमध्ये सुप्रीम कोर्टाच्या जजमेंटवर खूप कॉमेंट्स अशा आल्या की दॅट प्रोव्हिजन इज समवेअर लॅकिंग द कन्सेप्ट ऑफ कन्सेंट. इफ वी फोकस रादर दॅन मथुरा तरी नंतरचं होतं, त्याच्या आधीच्या काही केसेस जर बघितल्या, फॉर एक्झाम्पल यू कॅन फोकस वन गौरी शंकर्स वर्सेस स्टेट ऑफ बिहार केस इज देअर. आय थिंक इट वॉज ऑफ 1962-63 or I may not recalling the exact year, but you can find Gauri Shankar versus state, wherein the consent is too much restrained, and that has been interpreted by the apex court in the appeal. Gauri Shankar as well as Tukaram and others versus state of Maharashtra, that gamut has been right now changed. गौरी शंकरची केस किंवा तुकारामची केस जर आता घडली असती, म्हणजे 2013 नंतर घडली असती, तर तिथे प्लेनली कन्व्हिक्शन झालं असतं दोन्ही केसेसमध्ये, जे त्यावेळेस ऍक्विट झालेल्या केसेस आहे. Why I am focusing on this? Because by that judgment you can understand what changes have been takes place in the offense of rape. Naturally in practice we generally focus that some procedural aspect has been changed. काही प्रोसिजरल ऍस्पेक्ट चेंज झाले असं आपण बघतो जनरली प्रॅक्टिसिंग पॉइंट ऑफ व्ह्यू. सगळ्यांना माहिती आहे आता 354 ABCD किंवा 354चा गुन्हा असेल किंवा 375-76चा गुन्हा असेल, तर फिर्यादीचं स्टेटमेंट कसं घ्यायला पाहिजे, ते 164 खाली कसं नोंदवायला पाहिजे, ते सीलबंद पॉकेटमध्ये असायला पाहिजे, ह्या सगळ्या प्रोसिजरल ऍस्पेक्टच्या गोष्टी आहेत. ह्या मोस्टली प्रॅक्टिसिंग लॉयरला माहित असतात. पण प्रिव्हियसली कन्सेंटची जी कन्सेप्ट होती ती आता ड्रास्टिकली चेंज झाली. सो इफ वी सी द कन्सेप्ट ऑफ कन्सेंट इन तुकाराम अँड अदर्स वर्सेस गौरी शंकर, त्याच्यामध्ये सुप्रीम कोर्टाने एका गोष्टीवर कॉन्सन्ट्रेट केलं होतं. इट वॉज ॲक्विटेड ऑन द बेसिस दॅट द प्रोसिक्युशन हॅज अनेबल टू प्रूव्ह दॅट देअर इज नो कन्सेंट ऑफ द व्हिक्टिम सो फार ऑफेन्स ऑफ रेप इज कन्सर्न. Because when the victim has been retained in the police station, subsequently the offense of rape has been takes place, she never call anyone for her help, never dissent or never you can say that restrain for that act, and it commences in the consent of that victim. Basically तुमच्या ह्या इंटरप्रिटेशनलाच क्रिमिनल लॉ मध्ये खूप मोठी तफावत ह्या 2013च्या क्रिमिनल लॉ अमेंडमेंट मध्ये बघायला मिळते. सगळ्यांना कदाचित तुकाराम वर्सेस स्टेट ऑफ महाराष्ट्राचं जजमेंट माहीत असेल किंवा नाही. मी शॉर्ट मध्ये सांगतो काय झालं होतं. विदिन शॉर्ट, आय एम नॉट गोइंग इन द फॅक्ट्स. फॅक्ट मध्ये जायचं नाही आपल्याला. तुकाराम अँड हिज फ्रेंड वॉज कन्व्हिक्टेड by the trial court, acquitted by the trial court so far offense of rape is concerned, on the basis that the victim Mathura has not shows her objection so far offense of rape is concerned. ट्रायल कोर्टाने तिथे या दोघांनाही ऍक्विट केलं ऑन द बेसिस ऑफ द नॉन कन्सेंट ऑफ द वुमन. नंतर हायकोर्टामध्ये अपील गेली. हायकोर्टाने ही कन्सेप्ट ऑफ कन्सेंटची जी स्टेटमेंट और कंटेंट्स आहेत 375 मध्ये, ते वेगळ्या पद्धतीने इंटरप्रिट केले आणि तिथे परत कन्व्हिक्शन दिलं. दॅट अपील वॉज सॉट टू द अपेक्स कोर्ट. अपेक्स कोर्टाने 3 गोष्टीचा रेफरन्स घेतला. दॅट ज्यावेळेस विक्टिमला या आरोपी लोकांनी पोलीस स्टेशनमध्ये थांबवलं, बाकीचे लोक निघून गेले, तिने कुठलेही ऑब्जेक्शन घेतलं नाही. त्याच्यानंतर what act they have committed, during that she has not shown her disinterest, तिने कोणाला आवाज दिला नाही, आरडाओरड केली नाही, डिसइंटरेस्ट नाही दाखवला, असं सुप्रीम कोर्टाचं म्हणणं आलं. तिसरी गोष्ट, देर आर नो मार्क्स ऑफ इंजुरी ऑन द बॉडी ऑफ द विक्टिम, सो इट शोज दॅट शी इज हॅव्हिंग कन्सेंट, असा रेफरन्स अपेक्स कोर्टात झाला. आणि वन्स अगेन द अक्यूज हॅज बीन ॲक्विटेड बाय द अपेक्स कोर्ट बिकॉज वर्डिंग ऑफ सेक्शन 375. हे सगळं सुप्रीम कोर्टात जे झालं ते वर्डिंग 375 ची अशीच आहे म्हणून. बट नाव if we see the wording of section 375, which has drastically changed the definition of offense of rape, you can find the present situation in section 375 or definition of rape. Now see what I am saying. In previous statement, I have made the statement that Criminal Law Amendment Act 2013 has added almost 6 new things in this provision only. आधीचं 375 जर पाहिलं आपण तर त्या 375 मध्ये 5 प्रकारच्या सिच्युएशन्स होत्या, एक एक्सप्लेनेशन होतं, एक एक्सेप्शन होतं. रिमाइंड इट, आय रिपीटिंग. बघा आधीच्या प्रोव्हिजन मध्ये काय होतं, आता काय झालं ते बघितलं म्हणजे लक्षात येईल किती ड्रास्टिकली बदल झाला 375 मध्ये. आधी जर आपण 375चं प्रोव्हिजन पाहिलं तर त्याच्यामध्ये व्हेन ए मॅन कमिट्स और परफॉर्म सेक्शुअल इंटरकोर्स विथ ए वुमन, त्याच्या खाली 5 प्रकारच्या सिच्युएशन दिल्या होत्या, एक एक्सप्लेनेशन दिलं होतं, एक एक्सेप्शन दिलं होतं. एवढं 375 होतं 2013च्या क्रिमिनल लॉ अमेंडमेंट ऍक्ट पूर्वी. नाउ इफ वी ओव्हरलुक सेक्शन 375, you can find that in 375 4 kind of explanation deals with the penetration only. A man is said to commit rape if A, B, C, D, these 4 things which previously not there, now inserted in 375. Penetrate his penis, insert, manipulates, applies. These 4 things which has absent previously, now against her will, without her consent, these are the same thing which are available previously also, or which was in 375 previously. With her consent, when consent has been obtained, putting her or a person whom she is interested in fear or death, that 5 things are there. One thing added, that when she is unable to communicate consent, this is the new thing which is added by the Criminal Law Amendment Act. 7 नंबरचा जो क्लॉज आहे तो 2013 नंतर आला, that when she is unable to communicate consent. Now this clause, if applied to the Tukaram and others versus state of Maharashtra, this is purely offense of rape and that must be punished at any cost. So this is the new provision. Therefore I make the statement that if the Gauri Shankar's or the Tukaram's case takes place after 2013, that's are purely cases of conviction. Now this is 7th, that when she is unable to communicate, this is also newly added thing in Criminal Law Amendment Act 2013. Apart from that, in one explanation another explanation is given, means now there are 2 explanations in section 375, and in exception one exception is there, now 2 exceptions are there. So in explanation 1 thing added, in exception 1 thing added, in circumstances the 1 thing added, that 3, and previous 4 things of inserting the penis, that 4, these 3 and that 4, 7 things. Sorry, that previously I said 6, 7 things are newly added in 375 of Indian Penal Code, and it has covered the offense of rape in the constraint of this definition. So it has majorly changed the concept of offense of rape. Previously, the explanation placed the important role that penetration is sufficient to constitute. Up to what extent that is not important previously as well as now also. But the concept of explanation in previous act and present act has drastically changed. Now inserting the private part of male in any part as narrated under section 375 in opening section is included in the penetration. So that's are the drastic changes takes place in Indian Penal Code so far the offenses of rape is concerned. Therefore, I suggest that so far Criminal Law Amendment Act is concerned, for the interview of APP, you have to concentrate the previous and present situation. You must know that what are the new things bring by the Criminal Law Amendment Act. Because the panel may pin on the particular point whether the changes has been text of the offense of rape. Generally, the concept of rape is something different in the mind. Rape is naturally that the offense committed by a man with the woman against her consent. If we merely focus on the word rape, this is a Latin term comes from rapio. That is nothing but to seize, seizure. That is the actual meaning of the word rape, rapio. To seize or seizing something. That is the actual meaning. So seizing something, that is the base. Now seizing by all this manner which has contended in section 375, that amounts to the rape. Or you can say that when a man commit the sexual intercourse with a woman illegally, right? Now I am using the word illegally. Now illegal means all this manner which has contended under section 375 is called as an rape. So this is the drastic change in offense or sorry definition of rape by the Criminal Law Amendment Act 2013, and that must be understood by each and every. Generally what's happened that we focus merely on the offense of rape and increase punishment. आपण जनरली काय फोकस करतो की पूर्वी रेपची पनिशमेंट काय होती, आत्ताची रेपची पनिशमेंट काय होती. दॅट इज नॉट टू मच इम्पॉर्टंट. रेपच्या डेफिनेशन मध्ये जो ड्रास्टिक बदल झाला त्याच्यामुळे कन्व्हिक्शन रेट नॅचरली वाढेल. इफ वी फोकस नाउ दिस हे तर फक्त डेफिनेशन मधलं बोललो मी. इफ वी सी सेक्शन 376 सब क्लॉज 2 that has naturally changed the concept, though it is not called as an rape, but it brings lot of sexual acts of the employers and employee under the purview of this act. That has changed the previous situation. Means if we see section 376 subclause 2, previously it was recognized as custodial rape, but the concept of custodial rape has also undergone change by the Criminal Law Amendment Act, and that is required to be understood. Means this Criminal Law Amendment Act not merely increase the punishment, but it has widened the scope of the definition of rape, and that has to understand in appropriate manner. फक्त स्कोप वायडर केला असं नाही, बऱ्याचशा नवीन गोष्टी याच्यात ऍड केल्या. आणि म्हणून तुम्ही क्रिमिनल लॉ अमेंडमेंट ऍक्ट कुठूनही वाचायला सुरुवात कराल तर यू कॅन फाइंड दॅट क्रिमिनल लॉ अमेंडमेंट ऍक्ट ट्राय टू कव्हर द वेस्टर्नायझेशन इन द सोसायटी. And therefore, by the Criminal Law Amendment Act, it is required by the legislator to change the gamut of the offense of rape. Now, so far, the remaining part is concerned or further provisions are concerned, definitely we will continue it in the next session. So, hopes that today only we cover the introduction to the Criminal Law Amendment Act 2013. What are the provisions section 374 A, B, C, D, and merely the definition of rape which is narrated under section 375 of Indian Penal Code. In the next session, we will continue section 376, subclause 1, 2, and section 377. Now, I have stopped this live streaming. You may get confused that सर तिकडं पाहून का शिकवतात, कारण इकडं लाईव्ह स्ट्रीमिंग सुरू असतं, त्याच्यामुळे you are listening to me, you are not required to observe, so my concentration is more on this camera. So hope that you understand how to read section and how to understand the criminal law amendment act. मला असं वाटतं की याच्यातनं तुम्हाला क्रिमिनल लॉ अमेंडमेंट ऍक्ट मधलं नेमकं काय बघायचं याची एक आयडिया आली असेल. डिअर फ्रेंड, लेट मी टेल यू दॅट मी फक्त डिस्कशन करतो याचा अर्थ तुम्हाला सगळं परफेक्ट कळेल असं नाही. I only show the path. You have to start the reading and you have to understand what changes has been takes place. मी काही कम्प्लीट शिकवू शकत नाही. इवन नो वन कॅन टीच कम्प्लिटली लॉ टू एनीवन. म्हणून आपल्या डिस्कशन मधनं तुम्हाला नेमकं कुठे जायचंय, कुठल्या प्रोव्हिजनला फोकस करायचंय त्याचा संबंध लक्षात आला तर आपल्या सेशनचा डेफिनेटली काहीतरी फायदा होईल. सो डोंट मियरली रिलाय ऑन आवर डिस्कशन ऑर आवर सेशन, की आपण हे सेशन केले म्हणजे आपल्याला सगळ्या प्रश्नाचे उत्तर येतील असं अपेक्षित करू नये. ठीक आहे. सो फॉर टुडे वी विल स्टॉप हिअर. कोणाला काही विचारायचंय, बोलायचंय? येस, एनीवन? नो क्वेश्चन? मी बोलताना काही राहून गेलं असं कोणाला वाटत असेल तर प्लीज कंटेन इट, त्याचा सगळ्यांना फायदा होईल. Okay, hopes that everyone understand everything. So I will take credit of this. So shall we end the meeting? संपवायची मीटिंग?
Yes, sir.
Okay.
Yes, sir. Thank you. Thank you, sir. Thank you, sir. Thank you, sir. Thank you, sir.
याचा अर्थ अमेंडमेंट कोणच पाहिली नाही, कोणालाच काही नाही, हाच अर्थ आहे. The streaming will stop immediately. You will end म्हणायचं नाही याला.